Maryland v. Pringle, Supreme Court, 2003. Chief Justice Rehnquist delivered the opinion of the court. In the early morning hours, a passenger car occupied by 3 men was stopped for speeding by a police officer. The officer, upon searching the car, seized $763 of rolled-up cash from the glove compartment and 5 glassine baggies of cocaine from between the backseat armrest and the back seat. After all 3 men denied ownership of the cocaine and money, the officer arrested each of them. We hold that the officer had probable cause to arrest Pringle, one of the 3 men. At 3:16 a.m. on August 7, 1999, a Baltimore County police officer stopped a Nissan Maxima for speeding. There were 3 occupants in the car: Dante Partlow, the driver and owner, respondent Pringle, the front seat passenger, and Otis Smith, the backseat passenger. The officer asked Partlow for his license and registration. When Partlow opened the glove compartment to retrieve the vehicle registration, the officer observed a large amount of rolled-up money in the glove compartment. The officer returned to his patrol car with Partlow's license and registration to check the computer system for outstanding violations. The computer check did not reveal any violations. The officer returned to the stopped car, had Partlow get out, and issued him an oral warning. After a second patrol car arrived, the officer asked Partlow if he had any weapons or narcotics in the vehicle. Partlow indicated that he did not. Partlow then consented to a search of the vehicle. The search yielded $763 from the glove compartment and 5 plastic glassine baggies containing cocaine from behind the backseat armrest. When the officer began the search, the armrest was in the upright position, flat against the rear seat. The officer pulled down the armrest and found the drugs, which had been placed between the armrest and the backseat of the car. The officer questioned all 3 men about the ownership of the drugs and money, and told them that if no one admitted to the ownership of the drugs, he was going to arrest them all. The men offered no information regarding the ownerships of the drugs or money. All 3 were placed under arrest and transported to the police station. Later that morning, Pringle waived his rights under Miranda v. Arizona and gave an oral and written confession in which he acknowledged that the cocaine belonged to him, that he and his friends were going to a party, and that he intended to sell the cocaine or use it for sex. Pringle maintained that the other occupants of the car did not know about the drugs, and they were released. The trial court denied Pringle's motion to suppress his confession as the fruit of an illegal arrest, holding that the officer had probable cause to arrest Pringle. The jury convicted Pringle of possession with intent to distribute cocaine and possession of cocaine. He was sentenced to 10 years incarceration without the possibility of parole. The Court of Special Appeals of Maryland affirmed. The Court of Appeals of Maryland, by divided vote, reversed, holding that absent specific findings tending to show Pringle's knowledge and dominion or control over the drugs, the mere finding of cocaine in the back armrest when Pringle was a front seat passenger in a car being driven by its owner is insufficient to establish probable cause for an arrest for possession. It is uncontested in the present case that the officer, upon recovering the 5 plastic glassine bags containing the suspected cocaine, had probable cause to believe a felony had been committed. The sole question is whether the officer had probable cause to believe that Pringle committed the crime. The long-prevailing standard of probable cause protects citizens from rash and unreasonable interferences with privacy and from unfounded charges of crime, while giving fair leeway for enforcing the law in the community's protection. The probable cause standard is incapable of precise definition or quantification into percentages because it deals with probabilities and depends on the totality of the circumstances. We have stated, however, that the substance of all the definitions of probable cause is a reasonable ground for belief of guilt, and the belief of guilt must be particularized with respect to the person to be searched or seized. To determine whether an officer had probable cause to arrest an individual, we examine the events leading up to the arrest and then decide whether these historical facts viewed from the standpoint of an objectively reasonable police officer amount to probable cause. In this case, Pringle was one of 3 men riding in a Nissan Maxima at 3:16 a.m. There was $763 of rolled-up cash in the glove compartment directly in front of Pringle. 5 plastic glassine baggies of cocaine were behind the back seat armrest and accessible to all 3 men. Upon questioning, the three men failed to offer any information with respect to the ownership of the cocaine or the money. We think it entirely reasonable inference from these facts that any or all three of the occupants had knowledge of and exercised dominion and control over the cocaine. Thus, a reasonable officer could conclude that there was probable cause to believe Pringle committed the crime of possession of cocaine, either solely or jointly. A person's mere propinquity to others independently suspected of criminal activity does not, without more, give rise to probable cause to search that person. Where the standard is probable cause, a search or seizure of a person must be supported by probable cause particularized with respect to that person. This requirement cannot be undercut or avoided by simply pointing to the fact that coincidentally there exists probable cause to search or seize another or to search the premises where the person may happen to be. We hold that the officer had probable cause to believe that Pringle had committed the crime of possession of a controlled substance. Pringle's arrest, therefore, did not contravene the 4th and 14th Amendments.